Hello. In this clip from our Justia webinar, Content Creator Law by a Content Creator, Julian Serafian answered audience questions regarding social media, content creation laws, and how the legal industry is involved. If you want to see more Justia videos on law practice and legal marketing, be sure to subscribe to our channel. Hi, Julian. Thanks for joining us.
Hello.
All
How's it
right.
going, everybody? Thank you for joining us.
We can go ahead and dive right in. We've got, I think, 4 questions already. More rolling in. The first question we got was, what kind of checklist or something similar to that would be helpful in reviewing contract terms on behalf of content creators?
Yeah, I think so. It's a great question. The list of the terms that we walked through in this lecture are a great place to start. The thing that most creators care about are when they're going to get paid and whether or not the brand or the counterparty is allowed to use their content in perpetuity, or like if it's not in perpetuity, how long is that time frame? So I think the major points, besides general contract terms like termination or limiting indemnification, it's intellectual property and it's the payment terms. But when you approach these contracts, I encourage you to look at every provision with an eye for negotiating. That's what I did when I first started. And there's not a whole lot of consistency across the industry here because it's so young. And so you can have a hand in creating and generating market terms for your own little, client base, even if it's not quote unquote market or what other, brand side attorneys are dealing with. I see some of these other questions. I'll just run through and, feel free to draw them as I go through them.
Awesome.
Anonymous attendee. Well, there's a lot of anonymous attendee. Okay. Question is, what is the biggest or most common mistake you see content creators making while negotiating brand deals? It's handing away their name, image, and likeness. It's telling the brand, you have the perpetual right to use my name, image, and likeness forever without any further compensation. A lot of brands put that language in there because obviously it's great for them. And frankly, few brands have actually exercised this in a super egregious way, but that will absolutely change. And certainly with smaller creators, I have had some issues with brands abusing those provisions and just plastering the creator's name and face everywhere. So definitely the rights, to the creator's name, image, and likeness. Do state bars limit lawyers in this area? What about respect to contract governing law provisions? I think I'm not an expert in attorney ethics laws, but my read, and I did a fair amount of research into this, is if you're advising clients on general transactional contract law that does not relate or connect to a state specific jurisdictional, legal, body of knowledge, then I don't think you have much to worry about. And that actually includes provisions that are choice of forum and governing state law provisions. Because even when you're negotiating those provisions, for example, in my practice, I usually negotiate and change those to California. Even if they were New York beforehand, suddenly they're California now. So even if there was an ethical concern that, Julian's practicing New York law because this contract has a provision that says New York law governs, now it doesn't. Now California law governs because I negotiated that. So I think as long as you're not litigating in other states or, analyzing, for example, like employment law related issues in the context of the brand deals, you should be okay. What measures should creators take to prevent unauthorized use or distribution of their content online? As soon as you see it, you need to go after whoever is infringing on your content. You cannot train people into thinking it's okay to use your intellectual property. And I would say 95% of the time, if you're aggressive about going after them, and that means emailing them, it means using your own social media platform to go and put them on blast, say, look, everybody, these people are taking my content and I've asked them to take it down and that's not right and they're infringing on my copyright. Most of the time, the folks that are using it will take it down. And if they don't, then you have a couple of other options. You can contact an attorney like me, or you can go through the small claims copyright court in Washington, D.C. and file a formal action there. But in short version, you got to go after them. How do I stay informed about legal issues related to emerging tech, such as virtual reality or AI in the content creation space? Really good question. I read several Substacks that cover the legal world. One of them is called Point Two. It's by Matt Margolis. He's a fellow lawyer creator, and he does a lot of analysis of ongoing and very much what you said, emerging emerging virtual tech related cases, and that helps me stay in the loop. But also, I think all of this is bleeding edge, and the attorneys out there like myself that are deciding to work in this area of law that, especially with AI, is not really fully built out. We need to just do a really thorough job researching, for example, how AI will impact copyright law, and understanding like the policies that these platforms like OpenAI are providing to creators regarding intellectual property. Just staying on top of it as much as possible, and that includes reading the terms and conditions of these companies, and of course keeping up to date with legal news, like I said, with newsletters on Substack, and also like Law 360 and American Lawyer. There's a lot of good commentary out there. How do content creators navigate fair use issues without infringing on copyright laws? Better safe than sorry. Fair use is one of those things that it's not a reasonableness standard, but the key to think about is, does your content stand on its own without using the other media that you're showcasing that's somebody else's? If the primary value add or proposition in your piece of content is coming directly from that other piece of content that you're using, it's probably not going to fall under fair use. So in general, what I advise clients to do is either add their own commentary or change the content that they're sampling from so that it's not just directly replicating it, and that typically avoids fair use issues. I will say I will not speak specifically for music in this context, because music tends to be very, very protective, and it's very difficult to get away with sampling or using, for example, somebody else's music, aside from if you're using it as background noise in the video or like, the soundtrack. That's different because you're typically crediting the musician in these platforms. How do you handle revenue sharing negotiations with platforms? I usually defer to my client on what they expect. Different clients have different expectations. Some are saying, with a client I recently had with Snapchat, they wanted 50% of all of the profits. And they're like, I won't take anything less than that. Otherwise, this isn't worth my time. And so I honor what they want and I negotiate accordingly. But there's typically, I haven't personally found there to be any sort of market standard on revenue sharing with partners or platforms. It's typically whatever the client thinks is worth their time. And then of course, my job is to advocate and get that done in the agreement. Do state bars limit? Oh yeah, I think we hit that one. Have any content creators gotten insurance coverage for the wretched indemnity provisions? No, but that's probably a good idea, because as we talked about, that's a big red flag in these contracts, and it has huge implications for the creators. But no, not yet. Mostly because these creators probably don't know what they're doing. What the indemnification clauses actually operate to do. And by the time they find out, it's typically with me. And then when I'm involved, I will usually, negotiate on their behalf to limit indemnification. How has the rise of platforms like Patreon and crowdfunding impacted the legal aspects of content creation, and what precautions should creators take in those spaces? I think it's enhanced it. I think the more platforms that people are creating out there and companies provide that help the creator connect with their audience, I think that's only beneficial for the creator economy, because not all creators are created equal. One is going to be really big on YouTube. One's going to only do short form on TikTok. Some are going to be more like me that are like kind of omnipresent and then doing like written work. And some like to have, the more personal content behind paywalls so that they feel a deeper connection to their audience, like Patreon. So, I think the same issues that we've been talking about regarding protecting intellectual property, negotiating basic contract provisions in their favor, those apply equally, I think, irrespective of platform. With Patreon specifically, since you mentioned it, there's a concern there that since you're providing something that's behind a paywall, that somebody can reproduce it or post it elsewhere and then essentially violate the fact that it's supposed to be paid content. But in that case, we're back to the square one issue of what happens when someone is unauthorized. Someone who is not authorized takes your content, posts it elsewhere. What do you do in that scenario? And as we've discussed, you just got to go after them. So I think it's just a good thing, honestly. Just more platforms, more support for the creator community. It's only helpful, in my opinion. How do you counsel up-and-coming creators who want to sign multi-channel networks offering less favorable deals when they're laser focused on growing their audience or following? I give it to them straight, you know? And as a creator, I get it. When you're trying to grow and just get in front of people, you don't care what you're giving away because you're not making any money. You don't know if this thing is going to end up anywhere. It's basically a one-man startup. And there's no profitability at the beginning, and you're busting your back, you know, just to put out all the content. So I tell them, look, if your goal is to grow and you don't mind giving away this, here are the risks, and it's up to you. And you know, to your point, many creators who are hyper focused on growth, they don't care. They tell me, I don't care what I'm giving away. I just need to get this deal because I need to keep the business going and I need to grow, and it's just not that important to me yet. One related point, and I think I touched on this in the webinar, but a lot of creators don't see the value in hiring or getting legal counsel. Part of what I've had to do as a lawyer for creators is also educate the creator community broadly that it's important that you have some legal person, be it an attorney or a friend or even a paralegal, even someone, you know, in a management company that has some legal expertise. Somebody should be taking a look at these agreements because they can really, you know, bite them in the butt in the long term. So, all right. I think that is all the questions we got. Thank you, guys.
Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please hit the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next clip.